Hello, my name is Olivia Martz and my case is on the Winkelman and Parma City School District case. This case talks about the Winkelman family stating that the Parma City School District did not provide adequate placement for their child who happens to be on the autistic spectrum. They are fighting in court for pro se, which means as independent and non-lawyer parents. The facts of the summary is that Jeff and Sandy Winkelman claim that Parma City School District failed to give their son Jacob, who's disabled, an FAPE, which is free appropriate public education, as required by his IDEA, which is Individuals with Disability Education Act. Despite the Winkelman's oppositions, the school district planned to place Jacob in a public elementary school. After a preliminary school district hearing affirmed Jacob's placement, the Winkelmans placed Jacob in a private school at their own expense and petitioned a federal district court for reimbursement. The issue that the judge must decide is, in a lawsuit under the IDEA, may Jacob's parents, as non-lawyer parents, be able to fight on their own behalf and for Jacob as pro se, which means independent. The holdings is that yes, the court revised the Sixth Circuit by 7-2 vote, ruling that the parents enjoy rights under IDEA and that they are, as a result, entitled to prosecute IDEA claims on their own behalf. Justice Anthony Kennedy's majority opinion held that since the IDEA gives parents enforceable rights in the administrative stage of disputes over free appropriate public education, it would be inconsistent if they could not exercise the same rights in federal court. An interpretation where some rights adhere and both parents and child, while others adhere only the child, would be unnecessarily confusing and was not indicated by the text or structure of the IDEA. Therefore, the court ruled that a parent can be party aggrieved under the statute and sections referring to the rights of the child's need to be read and excluded by the parents. The dissenters would have held the IDEA gives parents the right to represent themselves in court when they seek reimbursement or challenge violations of their own procedural rights, but not when the challenge the adequacy of the child's free appropriate public education. Justice Antonin Scalia argued that the child, as the one who is receiving the education, is the only one with the right to it, and is accused that majority of spraying statutory sections about like buttshot create substantive parental right to education where none other exist. The reasonings why the court came to this decision is these laws listed, such as that FAP belongs to the child alone, and that parents play a significant role in the process of the IEP team, and that their concerns for their child are considered. These are a few of the laws that the court applied to the case and that were mentioned in court. And by relating these facts and the laws to each other, confirmed the ruling. The reaction and opinion would be simply that a child is provided free appropriate public education. Therefore, they must be able to exceed all of these rights. And as a future special education teacher myself, I'm going to constantly enforce all the rules and things they are allowed to receive in their IDEA. And I'm going to enforce that and make sure the student is covered with all of the accommodations needed. My conclusionary statement is that everyone under IDEA is mandated to have that free, appropriate public education, and that with this specific case, that the parents who are a part of that IEP team and the IDEA team, it results that since they are such a valid member of the team, they do have the right as the child's guardian to fight in certain circumstances. Thank you.